Hello friends, I'm Marjina Sultana, an assistant professor from International Law College, Greater Noida. Today we are going to discuss writs under administrative law. Writs is a constitutional remedy available to a person to bring his complaint or grievance against any administrative action to the notice of the court. Article 32 and 226 of the Constitution of India has designed for the enforcement of the fundamental rights and for a judicial review of administrative actions in the form of writs. There are five types of writs: habeas corpus, certiorari, prohibition, mandamus, and quo-warranto. The first important kind of writs issued by the court is habeas corpus. It means you may have the body. So the writ of habeas corpus is in the nature of an order directing a person who has detained another to produce the letter before the court in order to examine the legality of the detention, and if the detention was not justified, it was not a legal, there was no legal justification for the detention, then he will be set free. In ADM Jabalpur vs. Shivkant Shukla, it was observed that the writ of habeas corpus is a process for securing the liberty of the subject by affording an effective means of immediate relief from unlawful or unjustifiable detention, whether in person or private custody. So, if there is no legal justification for that detention, then the party is ordered to be released. The next important writ is the writ of certiorari, which means to certify. This writ is generally issued against authorities exercising quasi-judicial function, and this writ is corrective in nature. It can be defined as a judicial order of the Supreme Court or by the High Courts to an inferior court or to any other authority that exercise judicial or quasi-judicial or administrative functions to transmit to the courts the records of the proceedings pending with them for scrutiny and to decide the legality and the validity of the order passed by them. In A.K. Kraipak vs. Union of India, the Supreme Court issued the writ of certiorari to quash the selection list of the Indian Forest Service on the ground that one of the selected candidates was the ex officio member of the selection committee. The writ of prohibition is a judicial order issued to a constitutional or statutory or non-statutory body or person if it exceeds its jurisdiction or it tries to exercise a jurisdiction not vested upon them. So it is a general remedy for the control of the judicial or quasi judicial and administrative decisions affecting the rights of the citizens. So this writ is a preventive in nature, and it is said the principle is that prevention is better than cure. In the case of East India Commercial Company Limited versus Collector of Customs, a writ of prohibition, it was held that a writ of prohibition is an order directed to an inferior tribunal forbidding it from continuing with the proceeding therein on the ground that the proceeding is without or in excess of jurisdiction or contrary to laws of the land, statutory or otherwise. So this writ is issued when the authority exceeds its jurisdiction or it tries to exercise a jurisdiction which is not vested upon them, or it exercise contrary to the law of the land. Mandamus means we command. So the writ of Mandamus is an order issued to any inferior court or government or any other public authority to carry out public duty entrusted upon them either by a statute or by common law, or to refrain from doing a specific act which that authority is bound to refrain from doing under the law. So this it is a command of the superior courts to an authority, to inferior authority, to perform a public duty or to not perform an act which is against the law. So this writ of mandamus is available against the government, public servant and judicial body, but it is not available against the president of India, not against the governor, and also not against the private individual. For case study, you can refer to Sohanlal versus Union of India, AR 1957 Supreme Court, and the Raman and Raman versus State of Madras of the year 1959. It's also a Supreme Court cases. Quo-warranto means by what authority? It is a judicial order against a person who occupies a substantive public office without any legal authority. So the person who occupies a public office without authority is asked to show by what authority he occupies the position or office. So this writ is meant to oust a person who are not legally qualified for substantive public post. In in the case of University of Mysore versus Govinda Rao, the Supreme Court observed that the procedure of quo-warranto confers the jurisdiction and the authority on the judiciary to control executive action in making the appointments to public offices against the relevant statutory provisions. It also protects a citizen being deprived of public office to which he may have a right. From this case, it is clear that the writ of quo warranto review the action of the executive with regards to appointments made against statutory provisions to public offices, and it also protect those persons who deprived of their right to hold a public office. So we have discussed the writs in the nature of habeas corpus, certiorari, prohibition, mandamus, and a quo warranto. So thank you for watching.